Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Nick Esterbauer.
And I'm Shawnee Matinnia.
Welcome to Hull on Estates. You are listening to episode number 670. Welcome to the podcast, Shawnee.
Thank you.
This is our first time podcasting together and your first podcast with Hull and Hull. So very exciting day for both of us. And we thought we'd take the opportunity to talk about something that was, at the time of this recording, recently in the news. It was on everyone's mind. And it's also topical in a way to estate litigation. And it's not an issue we encounter all that frequently, but I think maybe we'll start off, Shawnee, by just taking a look at this news event and updating viewers and listeners who may be listening to this in months or years to come and making sure we're all on the same page here.
For sure. So essentially, as most of us are probably aware, and as most of us recently became sub-experts and water experts, the Titan Submersible.
Yeah, I remember, Shawnee, we were all in the lunchroom tracking the progress, waiting for an update. What's going on with the submersible? Is this going to be an unfortunate scenario that's going to turn into a movie, Titanic 2, although we discovered that there already is a Titanic 2?
Yeah, so essentially we were debating whether or not it would have been better to have the submersible implode and have a quick ending for the individuals in the sub, or whether or not they were stuck in there for a few days without food, without water, in a very tight and enclosed space. So it is unfortunate that the passengers are likely to have been deceased. That's most likely confirmed. And the investigators believe actually that it imploded on its way down to the Titanic. So pretty much day one, it imploded rather quickly and killing all of those on board. So it's bittersweet a little bit. Luckily, they didn't have to suffer through an unfortunate death. But nonetheless, this whole situation kind of made us think, well, what happens if something like this would happen in Ontario? What happens if someone we think is likely dead, but they haven't been officially declared dead, or we think they're missing, but and might be dead, but we're not fully sure. So it brought up a lot of those type of questions, because in estates litigation, these situations, although more rare, they do come up. And it's one of those that are very interesting, but we want to kind of figure out how to approach.
Yeah, so thankfully in Ontario, we do have the Declarations of Death Act, and pursuant to Section 2 of that Act, an interested person may apply to the Superior Court of Justice on notice to any other interested persons of whom the applicant is aware for an order declaring that that individual is dead. And we'll get to the actual requirements in order to satisfy the court that it's appropriate to declare that someone has died. But basically, we see two scenarios here. Either someone needs to have been absent and missing for a period of no less than 7 years, or they must have disappeared in circumstances of peril. Now, interestingly, that second component, again, is tied to a tragedy, 9/11. So it's the Declarations of Death Act 2002, and that's because after 9/11, the situations of peril language was added into the Declarations of Death Act to provide for what would happen in a situation like that, where it's very likely that someone is deceased, but they have not been missing for 7 years, and you don't have actual evidence that they've deceased. So typically when we're dealing with an estate administration, Shawnee, what we need is proof of death in order to apply for probate. That's going to be a death certificate. If someone has disappeared, you don't have a death certificate. And what you're going to need instead is an order or a judgment that's been made under the Declarations of Death Act. So I mentioned an interested person is someone who can apply under that act. Who is an interested person?
So the Act, in Section 1 of the Act, it actually defines what an interested person is. That could include someone that's been named as an executor in the individual's estate under their will, someone that can be entitled to be appointed as such. On intestacy, it could be a guardian or an attorney for personal care or attorney for property under the Substitute Decisions Act. It could also be someone who's in possession of property owned by the missing individual. If there's a contract of life insurance or a group insurance that issues the missing individual's life, it could be the issuer of that life insurance policy, or it could also be if the missing individual has been declared an absentee under the Absentees Act, but the absentee committee giving that declaration would also be allowed to be used in this scenario to define an interested person in this case.
So it's a hugely broad category of people who can apply. And I think that really highlights how you've got to have some really good proof that someone's disappeared in circumstances of peril or they've actually been absent for 7 years. Do you mind guiding us through a bit of that, Shawnee?
Sure. So the court doesn't really, the court does define what the circumstances of peril are. However, the Declarations of Death Act unfortunately does not. But nonetheless, the court has held and has continually held that it basically means a situation of serious and immediate danger. So that in and of itself, it can be considered broad, but the court really wants an fact-specific investigation to occur. They really want to know that there was sufficient evidence and details were taken in and a proper inquiry was conducted in order for them to conclude that the individual who is alleged to be missing is in fact deceased. The court really emphasizes this level of search because especially if the person was missing for 7 years, they really want a strong evidence to base their decision on before determining that someone was deceased and giving that declaration.
So ideally, we've got a voluminous record. It's containing all sorts of documentation in support of the inquiry that's been made into someone's situation. And if you've got, information about the situation in which they disappeared, if it's a situation of peril scenario. And I do want to go back just for a second to briefly mention the Absentees Act. We won't go into it in detail for the purposes of today's podcast, but that is sort of a less intrusive option. So you're dealing with the situation where someone maybe hasn't been gone for 7 years, maybe they haven't disappeared in a circumstance of peril, but they're missing, it's unknown where they are, and there may be issues arising in respect of their property that need to be dealt with during the interim period. So the Absentees Act in Ontario creates a legal mechanism for a missing person's affairs to be put under the management of what is still called a committee of that person's property. Now, for those who have been practicing estate and trust law and capacity law for longer, they'll recognize that term as being something not only we see in, I was about to say in the United States where it's actually a conservatorship. I was just thinking of Britney Spears for a second there. But it used to be a committee of someone's estate, which is now known as a guardian of property. So it's a similar sort of role. That person will be the litigation guardian for the missing person. And what we have seen in the past done on an application that's brought under the Declarations of Death Act is alternative relief sought under the Absentees Act. So if the court isn't satisfied that you've met the high burden of proof necessary in order to have a declaration of death, maybe you can still get an order under the Absentees Act so that things can move along during the interim period. Now, Shawnee, we don't have much more time, but we did briefly talk about the implications of one of these orders, a declaration of death, and what happens if in the end someone shows up. Let's say by some miracle, someone from the submersible shows up in 6 months and they've been declared dead.
So actually, the acts do contain provisions both respectively with regards to taking back the declarations of death if someone comes up out of the blue that they thought was dead and they declared them so. So ultimately, they are able to rescind or take back that declaration. You just have to take the appropriate steps to do so, which is detailed in both acts, respectively.
Really interesting to think about these issues. It's not something we encounter all the time, but I think recent news had us talking about this around over lunch a few weeks ago, and we wanted to make sure we covered it over our podcast. So I think that concludes today's podcast. Until next time, we want to thank you for listening. I'm Nick Esterbauer.
And I'm Shawnee Matinnia.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website. Thanks.
Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.